64. What is a probationary period?
Like employment at will, probation periods cause many employers headaches because probation periods are simply misunderstood. There's good reason for the confusion. Unions have historically allowed for probation periods in their collective bargaining agreements that granted management the right to terminate new hires at whim. Of course, that magical window only lasted about 60 or 90 days, but the probationary termination became the employer's contractual right. The union would not argue with the organization's right to terminate new hires who weren't performing up to par. On the other hand, non-union, that is, at will, employees are not covered by union contracts and do not have magical probationary periods during which they can be dismissed without censure. At-will employees can actually sue your company for wrongful termination even if it occurs at the onset of their employment. Hence the confusion. Whether employers have the right to terminate probationary employees on a whim depends on the union or non-union status of their workers. Still, companies try to retain as much flexibility with new hires as possible. As a result, non-union companies attempt to establish probationary periods where there is minimal, if any, obligation to provide workplace due process in the form of written warnings or other progressive disciplinary actions. Tell me more. If all or part of your workforce is covered by a collective bargaining agreement, then you've probably bargained for the right to include probation period language in the contract. Good for you. That right to terminate new hires on a whim, without cause or notice, is probably the most significant benefit that a union contract gives you. If you're an at-will employer, on the other hand, establishing a probation period is somewhat more difficult. In interpreting probation periods, courts typically look for some reason that they exist. Specifically, employees must receive some benefit upon completion of the period. As a result, you should ensure that there is some difference in your worker's employment status during the probationary period and after it. Allowing employees to enjoy some benefit, for example, accrued vacation, sick leave, or 401k participation, that they did not have before completing the probationary period typically accomplishes this. In addition, many companies have done away with the term probation because some courts have unfavorably interpreted probation periods. The reason? Historically, applicants and new hires, along with their attorneys, have construed probationary periods as minimum periods of job security during which they couldn't be fired, that is, until the end of the probation period. As a result, companies have replaced that term with introductory, evaluation, training, initiation, eligibility, or orientation periods. True, these designations may help avoid the undesired implications and assurances that the term probation has historically carried with it. However, a plaintiff attorney representing an ex-employee might still posit that your company did not have the right to discharge without cause or that your company engaged in some discriminatory practice, regardless of the existence of some introductory period. There's an even greater danger. Some labor experts discourage the use of probation periods at all. First, if employees are truly hired at will, then a probation period is superfluous. Second, some courts have ruled that the mere completion of such an initial evaluation period suggests express or implied contractual obligations that make it more difficult for companies to discharge at will. Specifically, the completion of the probation period could be construed to mean that employees have some greater right to job security in the form of workplace due process than they had while in their probation periods. Proponents of doing away with probation periods argue that employees are subject to the same standards of performance and conduct throughout their employment. Consequently, no probation period is necessary, and no implications of job security will arise for employees once these periods are over. I agree. However, you should discuss this concept with your labor counsel to find what's best for your company.